So the first case that really starts the process and gets the seesaw bouncing up and down is McCulloch versus Maryland. This Supreme Court case is important because it is the first case to operationalize the necessary and proper clause. That weird, sticky language that Congress has the powers necessary to implement the foregoing powers. This is where we see it used for the first time. McCulloch versus Maryland was decided in 1819, and it was a case about the establishment of the Bank of the United States. The federal government established the first Bank of the United States in the state of Maryland, but Maryland was afraid that it would be unfair in terms of competition, that people would maybe prefer to use the Bank of the United States instead of the individual state banks, that they just didn't want it there. So one of the things that they attempted to do was tax the existence of the bank, right? That the Bank of the United States would now pay taxes to the state of Maryland to try and shut it down. McCulloch, who was an employee at the Bank of the United States, objected to that tax policy and refused to pay the state's tax, which then causes the chain of events that gets us to the eventual decision in this case. When the Supreme Court rules, it's different than how any other court operates, right? We watch Judge Judy and all of those crappy daytime court shows. We watch, Law and Order. We watch shows that have this valorization of the criminal justice system, where more often than not, it's a determination of guilt or innocence. That is not what the Supreme Court does. That is not what higher federal district and circuit courts do. They are ruling whether or not something is allowable under the Constitution. They are acting as the referee. When cases come to the Supreme Court, they deal with a specific constitutional question. And in McCulloch versus Maryland, there are two. Question number one is the Bank of the United States constitutional? Because if the answer to this question is no, right, then bank goes away, the tax policy goes away, but Maryland is in the right. The Supreme Court finds that, yes, the existence of the Bank of the United States is constitutionally allowed to exist. And they use the necessary and proper clause to say that a bank is a predictable extension of some of the enumerated powers, right? The federal government in Article 1, Section 8 is given the ability to borrow and lend money, to hold minted money, right, to do the kinds of things that a bank does. So they use the necessary and proper clause to say that since the creation of a bank makes it easier for the national government to do all of those financial things, a bank is constitutional, even though it's not explicitly written about in the Constitution. The second question they have to ask is, can the states tax the federal government? And the answer to this question becomes no. And this is where we play with the supremacy clause that we talked about yesterday. Since the federal government is supreme, right, in questions of if things come into conflict, right, we know that the federal government will always be able to overrule the state governments. And in this instance, the supremacy clause is used to shut down the state tax policy because the Bank of the United States is constitutional, meaning that only the federal government could tax that entity. So John Marshall, who is the Chief Justice of the Supreme Court at the time, reaffirms both of those clauses, the supremacy and the elastic clause. And we can see that, right, the seesaw shifts, that the national government continues to get a little bit stronger than the states. The next clause of the Constitution that has been used in several decisions that have repercussions for federalism is the Commerce Clause. Article 1, Section 8, Clause 3 says, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with Indian tribes." So this sets up the ability for the national government to have power over interstate commerce. So anything that a state wants to do within its own boundaries is state power. But if the buying and selling of goods, if an act of commerce crosses state lines, then the federal government has the ability to regulate. There are two or three cases that we'll look at that deal with the Commerce Clause. The next one up is 6 years after McCulloch. It's in 1824, and it's the steamboat case. So what happens is Ogden receives a state license monopoly from the state of New York to run a ferry across the Hudson River. And if you're not familiar with your New York geography, the Hudson River is the river that is the river that is the boundary between New York and New Jersey. So he could use his steamboat to ferry people across that river from one state to the other. Gibbons, being a steamboat entrepreneur himself, wanted to get in on some of that money. He goes to the federal government and also gets a license to run his steamboat across the Hudson River. Ogden sues Gibbons because it's a violation of his monopoly. So this presents the constitutional question of, again, whose license should be held supreme, or which, should the monopoly be honored since the state of New York gave Ogden a license monopoly? Gibbons wins because Gibbons's license comes from the federal government. And the federal government has the ability to control commerce in this instance because they are touching two different states, right? It is not a steamboat that ferries people around the different, boroughs of New York City, where it only does business and only stops in New York. Because it crosses state lines, it's an act of interstate commerce that Congress has the ability to regulate. And with two relatively close decisions in a row, right, the federal government gets stronger now with the use of the Commerce Clause and the use of the Necessary and Proper Clause. It's not until around 1995 where we see a substantial decision that swings back in favor of the states, right? In this more than 100 years between Gibbons versus Ogden and the United States versus Lopez, we see more cases that empower the federal government. We'll talk in our essay practice about the Heart of Atlanta Motel case, which is around the civil rights movement, that gives the federal government the ability to regulate hotels that are on the interstate, that it just kind of continues to chip away at any power or authority the states have. But in 1995, we see the case United States versus Lopez, and the relevant law that you need to know that's in question is the Gun-Free School Zone Act. It's a law that was passed by Congress that says you cannot have a firearm within 1,000 feet of a school. We see those signs all over the place now, right? There's a gun-free, drug-free, and alcohol-free school zone act that says, I can't have a gun in my car. There are exceptions for places like Topeka High, right? Since our school is not nested off in some alcove that it sits at major intersections. If I'm driving past the school, it's not a violation of the law, right? So if I went to the liquor store and then drove past the school, I'm not in violation of that act. But if I park my vehicle in or around school property, then it may be a violation of any of those whatever free school zone acts. So Lopez, who's a high school senior at the time, carries a gun onto the school property. And this is not for a school shooting. It is a disassembled weapon that he is essentially selling to somebody else at school. And he's found in violation of the act and is sentenced to prison. He ends up suing, and it makes it all the way to the Supreme Court. And they ask, why does the state have the ability to, or why does the federal government have the ability to regulate these kind of practices around, schools? And the federal government makes the argument first that schools are sites of commerce, right? You have to pay some fees to go to school. You rent textbooks, you rent technology, you pay for lunch, right? There are goods and services that are exchanged at school. So it's an act of commerce. But there's not really a good, strong defense of how it's interstate, how schools cross state lines. And because both the commerce argument was weak and the interstate portion was weak, the law gets overturned. They end up passing the Gun Free School Zone Act as an opt-in thing that we'll talk about in a later set of notes. But it gets struck down because the regulation of guns, drugs, whatever, on school property has nothing to do with commerce. So it's not something that the national government can regulate. And for the first time, we see a significant decision that starts to swing some things back in the direction of the states, that they are getting more authority in the area of commerce, because we are seeing that no, not everything can be considered the buying and selling of goods. Things changed, though, in 2009, or 2005, sorry. So in 1970, Congress passes something called the Controlled Substances Act, which gives Congress the authority to regulate the creation, possession, distribution of certain kinds of drugs. So this can be stuff like they have the ability to regulate, the creation of legal medicine to make sure that, things get FDA approved, that they're safe for people, and all of that stuff. But this is also where we see the scheduling of drugs as illegal start to be rolled into law. In the year 2000 is when we start to see California be one of the leaders in terms of the medical marijuana movement, and they create medicinal marijuana. And this isn't just like, I'm sick, I need weed. To be eligible to have, medicinal marijuana, a doctor had to prescribe it to you for a specified set of conditions or illnesses. You had to go to a licensed dispensary where you also had to register, and they would keep track of what you were purchasing, right, and how much pot you bought, and that way they could make sure that you weren't just selling it to your friends. Raich, who is a woman who is dying of or is sick with cancer. I don't know if she dies or not from cancer, but she starts growing some of her own marijuana. This case makes it to the Supreme Court, and Reich's argument was that the Commerce Clause should not apply in her case because any of the marijuana she is growing is for personal and medicinal purposes. There's no commerce because she's not selling the weed to anybody, and there's definitely no state border issues because she's not taking her marijuana anywhere else. But the Supreme Court looks at this and uses this case as a lens to kind of roll back some of the medicinal marijuana laws that other states had passed. And on a 6-3 decision, the Supreme Court ruled that the federal government could overturn state laws or shut down state laws that permitted medical marijuana because of the Controlled Substances Act. So we see a new area where the states are trying to take some power, right? That states are trying to do some things on their own with drug legalization, and the Supreme Court shuts that down. We'll look at examples across the next couple of class periods of seeing whether or not the seesaw is in constant motion in terms of who is powerful or influential in a given area. But these 4 cases are important because they will be a basis for part of the essay test that we will do, and I'll walk you through how to construct the Supreme Court comparison essay, which is the third, it's free response question number 3 that shows up on the AP exam.